A basic rule says that a party can't be compelled to honor an agreement made under duress or by coercion. But what constitutes duress or coercion? A court considered that question in Chouinard versus Chouinard. Fred Chouinard, the president of ARC Security Incorporated, started the business in 1970. Fred, his twin brother Ed, and their father Al each contributed $2,000 to the startup company. But the nature of Ed and Al's ownership interest wasn't ever clearly established, even though the three men discussed it frequently. By 1974, the company was in financial distress. Several clients weren't paying their bills, and Fred had made a bad business investment. Things got worse when two banks withdrew lines of operating credit. ARC found itself short of operating capital and potentially unable to make payroll. A commercial lender offered financing, but only if the stock ownership dispute was resolved. Eventually, Ed and Al released their claims to the company. In exchange, Fred and his wife Ginger executed two promissory notes, one each to Ed and Al. Fred and Ginger would pay Ed and Al $5,000 each immediately, followed by installment payments totaling $90,000 each. Fred made the initial payments in February of 1974 and continued making payments until he filed suit in March of 1975. Thereafter, Fred voluntarily made the payments into the court's registry. Fred and Ginger sued Ed and Al in federal court, alleging that Ed and Al had used ARC's financial distress to coerce Fred and Ginger into making the agreement. A jury found that Fred and Ginger had executed the notes under duress, but had waived their duress claim by thereafter making voluntary payments. The district court granted judgment to Ed and Al. Fred and Ginger then appealed to the Fifth Circuit.